Good morning. I hereby call to order this 19th meeting of the Pennsylvania Public Utility Commission for the year 2024. We welcome everyone joining us in the room here today, as well as those joining us on the live stream. Please stand for the Pledge of Allegiance. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forms have been made available for public participation in cases before the Commission, there's no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. I will note that all 5 Commissioners are present today, with Commissioner Coleman joining us virtually. I also want to note that this is a special meeting. It wasn't on our original schedule, as we had another one of these meetings a few weeks ago. As you know, we are under a statutory deadline for rate cases. So as a result, we did have to add a few meetings to our agenda this year. And with that, the first matter on this morning's agenda is the approval of the minutes of November 21st, 2024. I would like to recognize Vice Chair Barrow as the editor of the minutes. Vice Chair Barrow.
Thanks, Chair. I have reviewed the minutes of the November 21st public meeting and move that they be approved as submitted.
You've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. The minutes are approved by a vote of 5-0. Madam Secretary, we're ready for your presentation.
Good morning, Mr. Chairman and Commissioners. Your various offices have prepared the following agenda items for this special public meeting of the Commission. Therefore, let us begin on page 1 with matters presented by Director Hafner and the Office of Special Assistance. It is recommended that the Commission adopt the proposed opinion and order in the application filed by Aqua Pennsylvania Wastewater regarding an acquisition of the Greenville Sanitary Authority in Mercer County, Pennsylvania.
Is there a motion to consider a staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yonora. Any discussion?
Mr. Chairman, I have a motion on the matter.
Commissioner Yonora.
I ask that my motion be entered into record as if I read it in its entirety. Before the Commission is the application of Aqua Pennsylvania Wastewater requesting approval of its acquisition of the Greenville Sanitary Authority wastewater collection and treatment system. The proposed acquisition will resolve the significant safety and operational deficiencies of the Greenville wastewater system, including hazard chemical storage, labeling, safety and dechlorination issues, wastewater treatment plant ventilation, physical safety, and security concerns, insufficient emergency power generation, and a limited availability of licensed operators. In addition, the proposed acquisition will address environmental deficiencies with the Greenville system. As part of the transaction, Aqua will invest approximately $20.4 million in planned upgrades to address certain DEP violations. Aqua has the expertise, licensed professionals, and capital to resolve the significant safety, operational, and environmental deficiencies in the Greenville system. When weighing all of these factors against the rate impact of this transaction, I believe that the acquisition benefits the public. As such, the application should be granted. Therefore, I move 1, that the exception of the Aqua Pennsylvania wastewater are granted consistent with this motion. 2, that the exceptions of the Greenville Sanitary Authority and Borough of Greenville are granted consistent with this motion. 3, the recommended decision issued on October 3rd, 2024, and this proceeding is modified consistent with this motion. 4, the application filed by Aqua Pennsylvania Wastewater for approval of its acquisition and a wastewater collection system assets of the Greenville Sanitary Authority is approved, subject to the terms of the conditions set forth in this motion. And 5, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
We've heard the motion by Commissioner Yonora. Is there a second?
Second.
Seconded by Commissioner Coleman. Any discussion?
Mr. Chairman,
Commissioner Zerfus.
Thank you, Mr. Chairman. I am going to be a no on this motion, and I have a statement to explain why that I'd like to add to the record as if I read it in its entirety. I'm not going to read it. I'm just going to submit it. But I would like to take a moment to thank the Office of Administrative Law Judge and the Office of Special Assistants for their thorough review of the evidence in the case, the careful consideration of the parties' positions, and their diligent application of the relevant case law. Thank you.
Thank you, Commissioner Zerfus. Any further discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please submit my statement as though read in its entirety. It is rather lengthy. I will not do that. But I also, so this case was difficult for me. When it comes to mergers and acquisitions, we've got sections 1102, 1103, and now section 1329 of the Public Utility Code. And these three sections of the law are somewhat, they're not working together that well, I don't think. So the commission still must abide by 1102 and 1103 of the code that provides that acquisitions have to provide a substantial affirmative public benefit. And then, on the other hand, in section 1329, we have to apply the financial valuation criteria in that section. And 1329 allows these mergers and acquisitions to proceed at a rather hefty premium. So that's why these cases are always difficult for me. It's trying to weigh those benefits of the deal with the cost of the deal and the rate impact on rate payers. There are many benefits to this deal compared to some of the 1329 deals that we've seen. The dollar amount, frankly, is a lot smaller. But at the end of the day, this is an acquisition that comes in at more than double what the system is valued at, and that cost will be spread amongst the rate base. And then I balance that with the fact that the Greenville system and the borough, this is work that they can do. They choose not to do it. That is on them, but that is not my concern. The fact is that they could do it, and they can do it for a lot cheaper for the ratepayers. So when I look at my obligations under 1102, 1103, and 1329, I would have to vote no on this one. Thank you.
Thank you, Vice Chair Barrow. Appreciate your comments. As we've discussed many times, this is a difficult issue. I do also have comments on this matter. I asked that my statement be entered into the record as I read it in its entirety. For the Commission is a recommended decision and exceptions thereto of the application of Aqua, Pennsylvania for approval to acquire the Greenville Sewer Authority, or GSA. The application was filed pursuant to sections 1102 and 1329 of the code. GSA is located in Greenville Borough, Mercer County, which serves 2,281 customers. GSA also provides bulk treatment service to Hemphill Township and West Salem Township. GSA's system has a depreciated original cost of $6.8 million. The application seeks approval of an asset purchase agreement valuing GSA's assets at $18 million. When reviewing 1329 applications, the Commission must determine whether or not the acquisition results in the overall affirmative public benefits. This analysis is unique for each application insofar as we must compare all potential harms, such as rate increases for the acquired entity and the acquiring utility, with all purported benefits, including improvements in service, security, and operations, as well as financial support for the acquired entity. There is no doubt that this acquisition, if approved, will increase rates to GSA's customers. However, I assert that such rate increases are necessary and prudent since the record here indicates GSA is indeed a distressed utility. According to the Greenville Borough, GSA has performed only reactive maintenance. Greenville Borough further states that GSA's assets are past their life expectancy and in need of replacement or major repair. GSA requires a complete overhaul of its system to address a consent order, an agreement entered into with the Department of Environmental Protection, entailing $46 million in required capital investment. Compounding this challenging situation are the financial circumstances of Greenville Borough, which just recently worked its way out of Act 47 distress status after 21 years, exiting that status only in November of last year. As GSA states in its main brief, the sale secures future financial stability for the borough and its residents and provides flexibility to make necessary future capital investments within the borough. Aqua indicates that it will remedy the consent order issues at approximately half the cost projected by GSA, generating savings of approximately $20 million. Further, Aqua has exhibited plans to modernize GSA's operations and billing, update GSA's physical and cybersecurity hygiene, provide payment assistance for income-eligible customers, and increase contributions to its hardship fund by an additional $25,000 for 3 years. I further note that GSA's existing monthly residential wastewater bills are approximately $28 a month. This is roughly 25 to 30% of the monthly residential tariff bills for major regulated wastewater utilities in the Commonwealth. As such, while rate increases will result from this transaction, such increases are indeed required to ensure safe and reasonable service and will still result in GSA's rates below those of other regulated customers in the Commonwealth. I contend that all these factors, as exhibited on the record, accumulate into a net overall affirmative public benefit. This substantiates the use of the 1329 fair market valuation to facilitate the distressed Greenville sewer authorities and formerly distressed Greenville boroughs exit from the wastewater utility operations. Is there any further comments? Hearing none. All those in favor, please say aye.
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 Those opposed, no.
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 The ayes have it. The motion passes by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, the matter passes as amended by a motion by a vote of 3-2, noting the dissents of Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Turning to page 2, it is recommended that the Commission adopt the proposed opinion and order in the proposed rate increase filed by the PECO Energy Company Electric Division.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chair, I have a joint statement between myself and Commissioner Zerfus.
Vice Chair Barrow.
So we have a settlement in this case, and the joint petitioners to the settlement agreed to an increase of $354 million annual operating revenue, or an increase of 22%. It is, as part of the settlement, PECO Electric also agreed not to file another general rate increase for its electric operations prior to March 16 of 26. And there are a lot of good settlement terms. For example, PECO is going to increase its LIRUP by $1 million, that budget. They are going to amend their matching energy assistance funds program to set the maximum grant at $1,250 per account, and that will no longer be limited to a zero balance target. The electric vehicle charging pilot will extend through 2029. The credit's going to be calculated at 30% rather than 20% of measured demand. PECO is going to participate in the DHS data sharing program, which I believe will definitely help its customers. And PECO also will work with the Philadelphia Energy Authority with their Solar for All program and also for their Built to Last program. So all in all, we are definitely pleased to see PECO's work, especially the work with the Philadelphia Energy Authority. We believe that braiding together externally funded programs such as these with ratepayer-funded universal service programs such as LIREP, and potentially with Act 129's Energy Efficiency and Conservation Program, will realize efficiencies in spending and lower energy bills for customers. Now, that being said, we do want to highlight some of the issues raised by the IBEW in this proceeding. First, IBEW raised concerns with PECO's customer service reps' handling of the rollout of their new customer service platform. And I'm not going to go through all of them, just a couple. But so IBEW attributes some of the highlighted issues to inadequate training of the customer service reps and their supervisors. We acknowledge that the rollout of this new platform was in response and in compliance with the Commission's 2022 audit report to improve customer service. And we also acknowledge that the issues identified by IBEW were experienced during the early stages of the rollout. PECO has said that it has ensured that customer service rep training has improved, and they agree in the settlement to investigate any material issues with call handling that were identified in the 2022 audit report. The company also agrees in the settlement to file a report on its investigation of call center performance within 6 months of the effective date of the new rates established in this proceeding. However, we do believe that the issues identified by IBEW, if found to be true, are separate from the commitments PECO made in the settlement. While IBEW's proposed modifications to PECO's customer service rep training related to this new system may appear to be premature, we find that the issues raised by the union are worthy of investigation and would recommend that PECO and the Commission take a closer look. With regard to IBEW's proposals relating to PECO's personnel vacancy rate, workplace planning, wage increases, and the one-time union contract notification, the judges found that many of IBEW's requests seeking relief are beyond the Commission's authority. We disagree. As highlighted by the union, to the extent that the areas of employee vacancy affect the calculation of wages and benefits, post fully projected future test year cost recovery, recovery of certain aspects, recovery of certain costs or additional reporting requirements that provides useful information in future rate cases, we do not believe these issues are outside of the Commission's regulatory boundaries. Section 504 of the Code does provide that the Commission can require periodical filings on topics concerning any matter whatsoever which the Commission is authorized to inquire or to keep itself informed of, or which it is required to enforce. So further on the issue of the annual schedule of affiliate transactions, report required by IBEW, we agree with the ALJ's recommendation to refer this matter to the Commission's Bureau of Technical Utility Services for further review. While we would prefer to grant IBEW's exceptions numbers 3, 4, and 5, on the balance, we find that the proposed settlement is in the public interest. Also, we'd like to take this opportunity to again note the unprecedented recent load growth across the country and in the Commonwealth of Pennsylvania. With this load growth, there should be concurrent rate impacts. The logical expectation of large load growth would be longer periods between rate case filings, or even some sort of amelioration of rate increases. And, that remains to be seen in the future. But we look forward to a robust vetting of this issue in future filings. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I do have a statement in this matter that's combined with the gas case. I will read it when the second matter is considered. Any further comments?
One more comment.
Vice Chair Barrow.
My statement was a lot longer. I don't know if I asked that it be.
So you increased it. So we didn't shorten it.
It was actually longer. Please submit it to the record as though read in its entirety.
Gotcha.
Mr. Chairman, before we get to the vote, I just wanted to specify that, and first thank Vice Chair Barrow for reading our joint statement, but for the reason she explained in the statement, I am going to be dissenting in part as it relates to IBEW exceptions, and then approving in part. But for the purposes of recording the vote, I would be a yes.
Okay. Any further comments? Hearing none. All those in favor, please say aye. Aye.
Aye.
Those opposed, no. The ayes have it, and the matter passes by a vote of 5-0,
Sure.
noting.
I'm sorry. I should have been clear. I am a partial dissent, but please record me as a yes.
Okay.
All right.
So the vote is still 5-0 with partial dissents by Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Turning to page 3, it is recommended that the commission adopt the proposed opinion and order in the proposed rate increase filed by the PECO Energy Company Gas Division.
Is there a motion to consider the staff recommendation?
So moved.
So moved.
Motion made by Commissioner Yanora, seconded by Commissioner Coleman. Any discussion?
Chairman, I do have a statement.
Vice Chair Barrow.
This, again, is a joint statement between myself and Commissioner Zerfus. It is largely, I ask that this statement be entered into the record as though read in its entirety. I will not read it. It would be repeating our statement in the electric case. I once again would like to be recorded as a yes vote, but note my partial dissent. Thank you.
Thank you. Any further comments? Do you want to go?
I mean, ditto, right? So partial
Yeah,
dissent, thank you, and but recorded as a yes.
Any further comments? I do have a statement in this case. I ask my statement be entered into the record as though I read it in its entirety. Before the commission are the proposals of the PECO Energy Company to increase the base rates related to electric and gas divisions and the non-unanimous settlement petitions for each respective case. As also before the commission are the exceptions filed to the recommended decisions of administrative law judges Darlene Heap and Marta Gould in each matter. For the electric division, the settlement provides for rates designed to produce a net annual revenue increase of $290 million compared to PECO's original request for a net annual increase of $399 million. For the gas division, the settlement provides for rates designed to produce an increase of $78 million in annual revenues compared to PECO's original request of $111 million. In addition to the lower agreed-upon rate increases, the settlement petitions contain a number of other provisions that, in my view, are reasonable and in the public interest. These include reporting requirements documenting actual expenses and rate-based additions, which would allow more accurate gauging of PECO's fully projected future test year estimates, additional protections and supports benefiting low-income customers, and the extension of and enhancements to PECO's electric vehicle charging pilot and EV fast charging pilot rider. Such provisions may have not been attained if the matter were fully litigated. Among the Universal Service Program commitments the PECO made in the settlements is an agreement to convene a stakeholder group to discuss how PECO could automatically enroll customers who receive LIHEAP grants into PECO's customer assistance programs. Identifying and providing universal service benefits to all eligible customers is a worthy endeavor. However, I wish to emphasize certain issues that I believe the parties should consider. Participation in CAP comes with benefits as well as certain forfeitures. For example, participating in CAP can prohibit a utility customer from being awarded a commission-approved payment arrangement and may require an electric customer to terminate service received from an electric generation supplier and return to default service. At a minimum, non-CAP LIHEAP customers should be provided with all relevant information before any transfer to CAP occurs. I encourage the stakeholders to discuss whether CAP enrollment in this situation should be automatic with provisions to opt out during a certain period of time, or whether consent is necessary to opt into CAP. While I understand that CAP offers favorable payment terms and addresses arrears, customers should be informed about any potential adverse impacts associated with participating in CAP. I also wish to address the issue that was fully litigated in PECO's requested rate increase for its gas division, the proposal to implement a weather normalization adjustment. Properly designed WNAs can insulate customers from high bills during extremely cold months while allowing a gas utility to support its fixed costs during unseasonably warm heating months. In fact, the Commission has approved WNAs in other instances. In this case, however, I would have preferred a WNA proposal containing a 3% deadband instead of a 1% deadband. A 3% deadband would allow for a greater range of what is considered normal weather and would be consistent with existing WNAs approved by the Commission. Had PECO's proposal contained more common elements, such as those present in other gas utility WNAs, I would have been inclined to view PECO's WNA favorably. Finally, I would like to commend all active parties in both proceedings and Commission staff who worked on these matters. Your input has resulted in what I believe to be a reasonable resolution of issues raised. Any further comments? Hearing none, all those in favor, please say aye. Aye.
Aye.
Those opposed, no. The ayes have it by a vote of 5-0, noting the partial dissents of Vice Chair Barrow and Commissioner Zerfus. Madam Secretary.
Mr. Chairman, that concludes the regular agenda. Turning now to the carry-in. It is on page 1 of the carry-in agenda. It is recommended by the Law Bureau that the Commission adopt the proposed statement of policy regarding the sunset of Chapter 14 of the Pennsylvania Public Utility Code.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion? I do have a motion in this matter. I ask the Vice Chair Barrow chair the meeting.
Chairman DeFrank, your motion.
Thank you, Vice Chair Barrow. I ask that my motion be placed into the record as though I read it in its entirety. I apologize. This is a very long motion. This is a big issue. We did attempt to condense it for the read version of it, but nonetheless, it is still a long version, a long motion. In 2004, the General Assembly added Chapter 14 to the Public Utility Code, seeking, among other things, to eliminate opportunities for customers capable of paying utility bills to avoid timely paying those utility bills. This was the first significant change to rules regarding utilities' residential service standards with respect to billing and related issues in more than 25 years. In Chapter 14, the General Assembly determined that the rules had not successfully managed the issue of bill payment and that increasing amounts of unpaid bills threatened paying customers with higher rates due to other customers' delinquencies. The goal of Chapter 14 was to increase timely collection while ensuring that service is available to all customers based on equitable terms and conditions. The General Assembly issued a sunset of Chapter 14 in 10 years unless reenacted. Chapter 14 was reenacted in 2014 again with another 10-year sunset provision. In response to the enactment of Chapter 14, the Commission initiated a rulemaking to amend Chapter 56 of our regulations. Chapter 56 pertains to standards and billing practices for residential public utility service. Those final form regulations became effective upon publication in the Pennsylvania Bulletin on October 8, 2011. Chapter 56 was amended in response to the 2014 reauthorization effective June 1st, 2019. Now we face the anticipated sunset of Chapter 14 on December 31st, 2024. As a result, before the Commission for consideration is a statement of policy seeking to inform affected utilities, consumers, and other interested stakeholders of the regulations at 52 PA Code Chapter 56, that govern existing procedures regarding residential utility service remain in effect until amended. The statement of policy references the Commission's obligations under Chapters 13 and 15 of the Public Utility Code to ensure that utility rates and tariffs are just and reasonable. The statement of policy also references Sections 703E and G of the Public Utility Code, which provides the final payment arrangement orders are presumed to remain in effect unless reversed on appeal or amended after notice and opportunity to be heard. Finally, the proposed statement of policy determines that while the Commission can take action to amend Chapter 56 regulations through the initiation of a rulemaking process after providing notice and an opportunity to be heard, it is the Commission's present view that all final orders issued pursuant to Chapter 14 remain in effect and are enforceable by the Commission. I support the proposed statement of policy. It provides regulatory certainty to utilities, consumers, and all affected stakeholders regarding how issues contained within Chapter 14 will be addressed. Moving forward, further, the statement of policy will mitigate unnecessary expenses and administrative burdens for the utilities and the commissions by maintaining the existing regulatory paradigms. Finally, by maintaining the existing regulatory posture and continuing to enforce all final orders pursuant to Chapter 14, the statement of policy provides a reasonable backstop to allow more time for the General Assembly to continue deliberating reauthorization into the future. However, I believe the statement of policy, as proposed, would benefit from further clarity. For example, with regard to the provision of payment arrangements, and without prejudging any future matters that may come before us, I believe the Commission should maintain its application of the four-tiered process establishing the length of payment arrangements currently articulated in Chapter 14. This includes principles provided in Section 1405C and the relevant definitions of change in income and significant change in circumstance as provided in Section 1403. As Chapter 14 currently requires, the length of time for a customer to resolve an unpaid balance that is investigated by the Commission and is entered into by a public utility and customer should continue to be based on the four tiers of 5 years, 3 years, 1 year, and 6 months, depending on the gross monthly household income level in relation to the federal poverty level. Therefore, I submit that, for example, it should be the Commission's intentions that the principles in Section 1405 and definitions in Section 1403 should continue after the expiration of Chapter 14 on December 31st, 2024. Relevant legal authority to support the continuation of payment arrangements includes the Commission's jurisdiction and authority over the regulation of public utilities generally under Section 501, reports by public utilities under Section 504, just and reasonable rates under Section 1301, discrimination rates under Section 1304, the advanced payment of rates under Section 1305, the character and service of facilities under Section 1501, discrimination in service under Section 1502, the discontinuation of service under Section 1503, and the standards of service and facilities under Section 1504. The Commission also has relevant authority under Section 308.1 regarding consumer protection and information, including informal complaints, Section 505 regarding the duty to furnish information to the Commission, Section 506 regarding the inspection of facilities and records, Section 701 regarding complaints, and Section 1509 regarding billing procedures. Furthermore, in Chapter 56, Section 56.151 on Public Utility Company Dispute Procedures provides that upon initiation of a dispute covered by this section, the public utility shall make a diligent attempt to negotiate a reasonable payment agreement if the customer or occupant is eligible for a payment arrangement and claims a temporary inability to pay an undisputed bill. Likewise, Section 56.97 on notice procedures prior to termination provides that the public utility shall exercise good faith and fair judgment in attempting to enter a reasonable payment agreement or otherwise equitably resolve the matter. These provisions, along with other provisions throughout the Public Utility Code and years of commission precedent, which have sources of authority beyond Chapter 14, remain in effect and are not changed by the sunset of Chapter 14. By way of further example, given the public interest in this matter, the Commission intends to continue to enforce many important Chapter 56 provisions, including, but not limited to, medical certification protections and protections from abuse, and protection from abuse protections and the winter moratorium. In conclusion, it is the Commission's obligation to protect consumers by availing them of just and reasonable access to utility service and associated payment terms. However, the Commission must also maintain equitable service provisions for utilities to ensure they have reasonable tools to recover their costs. I believe maintaining the status quo in this regard is in the public interest as it protects the interests of utilities, customers, advocates, and this Commission during the pendency of continuing Chapter 14 reauthorization discussions by the General Assembly. Therefore, I move that 1, the Law Bureau prepare a statement of policy consistent with this motion. 2, that a copy of this statement of policy be served upon the following: all jurisdictional electric distribution companies, all jurisdictional natural gas distribution companies, all jurisdictional steam heat utilities, Philadelphia Gas Works, the Energy Association of Pennsylvania, all jurisdictional water public utilities and wastewater public utilities, Pittsburgh Water, the Commission's Bureau of Investigation and Enforcement, the Commission's Office of Administrative Law Judge, the Commission's Bureau of Consumer Services, the Pennsylvania Office of Consumer Advocate, and the Pennsylvania Office of Small Business Advocate. 3, that this statement of policy be published in the Pennsylvania Bulletin. Thank you, thank you, Vice Chair Barrow.
Thank you. Is there a second on the motion?
Second.
Second by Commissioner Yanora. Any discussion on the motion? Hearing none. All those in favor of the motion say aye.
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 Aye. Any objections? Hearing none. On final adoption, is there any objection to using the previous roll call? Then the recommendation is adopted as amended by a motion of 5-0. Thank you, Chair.
Thank you, Vice Chair Barrow. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you. If there is no other business to come before the Commission, is there any objection to adjourning the meeting? Hearing none, we are adjourned.